Good evening. There are growing calls tonight for a public inquiry into the Robert Pickton case as more details emerge.
She woke up in the middle of the night to a light burning inside the slaughterhouse. She walked across the yard to check what it was. She opened the door. And whatever she saw on the other side of that door, she never described in full. Not to a friend, not to a family member, not to the police. Not for 7 years. What she did next tells you everything about this case. She ran back to the trailer. She went to sleep. And the next morning she stayed on the farm. Here is what makes that detail significant. She later admitted, under oath in a court of law, that she had used what she saw to blackmail the man who owned that farm, more than once. She had leverage over him. Direct, specific leverage. And she still never called the police. Her name is Lynn Ellingson. The man she blackmailed is Robert Pickton. This case is not only about what one man did. It is about how many people knew pieces of it, and what happened to 49 women because those pieces were never put together. If this is your first time on Fatal Files, we cover cases exactly like this one. Cases where the crime is only half the story. Subscribe and hit the bell. Now, let's go back to the beginning. In the 1990s, Vancouver, British Columbia was consistently ranked among the most livable cities in the world. Low crime rates by international standards, a strong economy, a reputation for progressive politics, and a geography that most cities could only envy. Ocean to the west, mountains to the north, mild climate year-round. 10 blocks from the downtown core, none of that applied. The downtown Eastside, a neighborhood locals called Low Track, carried the distinction of being Canada's poorest postal code. East Hastings Street was its main artery. Open drug transactions happened in daylight. Chronic homelessness was concentrated here at levels that had no equivalent elsewhere in the country. By the mid-1990s, the HIV infection rate in this neighborhood was the highest in North America. A public health crisis that drew international attention but minimal government intervention. By the late 1990s, roughly 80% of women working in the street sex trade in this area had come from somewhere else. Runaways. Indigenous women who had left reserve conditions with nowhere stable to go. Women managing addiction with no access to treatment. What they shared was disconnection. From family, from support systems, from any institution that might notice if they disappeared. Between 1995 and 2001, at least 65 women did disappear from this area. Families filed missing persons reports. For the most part, those reports went nowhere. The women on the street understood the situation better than the agencies around them. Between 1999 and 2001, the Prostitution Alternatives Counseling and Education Society surveyed 183 sex workers in the downtown Eastside. What they found was a population living under constant threat, robberies, violence, forced confinement, and one with a near-total distrust of police. The women had started keeping their own records, writing down license plates, walking in groups, passing warnings to each other quietly. They knew something was wrong. The institutions around them had access to the same information and reached a different conclusion. Detective Inspector Kim Rossmo was the first Canadian police officer to earn a doctorate in criminology. In 1998, he ran a geographic profiling analysis of the disappearances, a data-driven method used to identify likely offender behavior patterns. His conclusion was specific. A serial predator was deliberately selecting victims from the downtown Eastside. His unit at the Vancouver Police Department was shut down shortly after. He was effectively pushed out of the department and left in 2001. He later filed a wrongful dismissal lawsuit, which he did not win. His analysis was confirmed the following year. Detective Constable Lorimer Shenher was assigned as the lead investigator on the missing women cases in July 1998. She built and maintained a detailed tracking database on the Canadian Police Information Centre entirely on her own, with no dedicated resources and no institutional backing. She pushed repeatedly, formally and informally, for surveillance authorization and a search warrant on one specific suspect. She was denied every time. She later documented everything in a 289-page manuscript titled A Lonely Section of Hell, which was submitted as evidence at the Missing Women Commission of Inquiry years later. The name she kept pushing was Robert Pickton. Before this story goes any further into the investigation, the evidence, and the people responsible for both, it needs to stop here. Because the easiest thing a case like this can do is reduce 49 women to a number. A body count attached to a killer's name. That is not what happened. These were specific people with specific lives, and the record of who they were deserves more than a footnote. Marnie Fry was 24 years old. Friends described her as gentle and trusting, someone who extended good faith to people even when they had not earned it. She kept a journal. She filled it with writing and drawings. Her family reported her missing and waited. Her remains were not identified until 2002, 5 years after she disappeared in August 1997. She is considered the first confirmed victim in this case. Serena Abotswe was 29. She had a daughter. On the streets of the downtown Eastside, she was known for looking out for other women, warning newcomers about dangerous situations, sharing what little she had. In August 2001, she told friends she was going to make some quick money and would be back that evening. She did not come back. Georgina Faith Papine was 34, an Indigenous woman who stayed connected to her family even through the most difficult periods of her life. She called regularly. That connection mattered to her. When she disappeared in March 2001, her sister Cynthia Cardinal did not accept the silence. For the next 6 years, Cardinal pushed publicly and persistently for answers, filing reports, speaking to media, refusing to let her sister's name fade from public attention. Mona Wilson was 26. Her case became one of the first forensic confirmations linking the farm to the missing women. DNA from her blood was matched to samples found in a motor home on the property. Her remains were recovered in June 2002. Andrea Joesbury was 22 years old, one of the youngest of the confirmed victims. Brenda Ann Wolfe was 32. She was among the first victims whose remains were positively identified during the forensic search of the farm. These 6 women, Marnie Fry, Serena Abotswe, Georgina Faith Papine, Mona Wilson, Andrea Joesbury and Brenda Ann Wolfe, are the women Robert Pickton was ultimately convicted of killing. But they were not the only ones. 20 additional women had their cases built, their evidence gathered, and their names formally attached to charges, and never saw those charges go to trial. Their names are Marianne Clark, Diana Melnick, Cara Louise Ellis, Tanya Holick, Andrea Faye Borhaven, Sherry Irving, Helen May Hallmark, Cynthia Felix, Carrie Lusick, Inga Monique Hall, Sarah DeVries, Angela Jardine, Jacqueline McDonnell, Wendy Crawford, Jennifer Firminger, Tiffany Drew, Dawn Teresa Cray, Deborah Lynn Jones, Patricia Johnson, and Diane Rock. Each of those names has a family attached to it. Tanya Holick's cousin Lorelei Williams became one of the most consistent public voices pushing for the preservation of evidence from the investigation. Evidence the RCMP later sought to destroy. In 2023, Lorelei Williams spoke at a press conference alongside family members of Sarah DeVries, opposing that destruction. Sarah's sister Maggie DeVries had already spent years documenting Sarah's life in a book titled Missing Sarah, one of the most direct accounts of what was lost in this case, written not by a journalist or investigator, but by a sister who simply refused to let her become a statistic. These women are the reason this case exists. Everything that follows, the investigation, the failures, the trial, the inquiry, exists because of what happened to them. Robert William Pickton was born on October 24, 1949, in Port Coquitlam, British Columbia. His parents, Leonard Francis Pickton and Louise Helene Arnold Pickton, ran a pig farm at 953 Dominion Avenue, a working property that would later become the largest crime scene in Canadian history. Leonard was born in 1896, Louise in 1912. By the time their children were growing up, the farm was the center of everything: the work, the income, the daily structure of family life. The Picktons had 3 children. Their oldest, a daughter named Linda, was sent to live with relatives. The reasoning, as it was later described, was that a pig farm was considered no place for a girl to be raised. The 2 boys, Robert and his younger brother David, stayed. What that childhood looked like in practice was documented through school records and later witness testimony. Both boys were routinely sent to school in unwashed clothing that smelled of the farm. Classmates gave them a nickname, Stinky Piggy, and it followed them. They had no friends. They sat apart. The isolation was consistent and chronic, not occasional. Robert struggled academically from an early age. He was placed in special education after failing grade 2 and dropped out of school entirely at 14 in 1963. He had no qualifications, no social network, and no path that anyone around him appeared to be helping him find. What came next was the one area where he developed genuine competence. After leaving school, he found work as a meat cutter and spent the better part of 7 years in that trade. He learned the work thoroughly. By the accounts of those who worked alongside him, he was skilled and methodical. For the first time in his life, he was good at something. There is one incident from his childhood that investigators, psychologists, and journalists have returned to repeatedly when trying to understand what shaped him. At around age 12, Robert used his own savings to buy a calf. He cared for it himself for approximately 2 weeks. Fed it, tended to it, formed an attachment to it that he had not formed with people. Then one day he came home and could not find it. He went looking. He found it in the slaughterhouse, already processed. His mother had had it killed without telling him. The event is documented not as an excuse but as a data point. The one attachment he had formed had been disposed of without acknowledgement. The people who were supposed to protect him had treated something he valued as property to be processed when convenient. When his parents died in the late 1970s, Louise in 1979, Leonard in 1978, Robert and David inherited the farm. Estate proceedings later documented in court records, including those referencing Louise Pickton's will under 2007 BCSC 1297, showed that Louise had maintained significant control over the farm's financial and personal structure even through her estate. Robert received his share of the inheritance. He and David sold off portions of the land for development, generating a combined total of approximately $5.16 million Canadian dollars. Robert kept a section of the property for his pig operation and a vehicle salvage business he ran with his brother. He lived alone in a trailer on the property. Parts of it had no running water. He accumulated junk around it over the years. He never married. He had no recorded relationships of any duration. He sought companionship by paying for it. One detail stands out when considered against what came later. Robert Pickton did not drink. He did not smoke. He did not use drugs. The substances that became his primary tool for accessing victims were never personal habits. He used them as currency, a means of building access and trust with women who needed them. That distinction matters to understanding how he operated, which this documentary will get to. Neighbors who knew him described him as quiet, hard-working, and entirely unremarkable. Nothing about the way he presented himself to the outside world suggested what was happening on that farm. In 1996, Robert and David Pickton registered an organization called the Piggy Palace Good Times Society. On paper, it was a non-profit charity. Its stated purpose was raising funds for community service organizations through special events. It was granted non-profit status on that basis. What it actually was is considerably different. The Pickton brothers converted a building on the farm property into an event venue and began hosting large-scale parties. These gatherings drew crowds of up to 2,000 people. Bikers, Hells Angels members, drug dealers, and women from Vancouver's downtown Eastside who were brought out to the farm. Accounts from the period suggest that local political figures and business people also attended at various points. The events were loud, unregulated, and entirely outside the boundaries of what the nonprofit registration had described. Pickton's role at these parties was consistent. He moved through the crowds distributing cash and drugs. He built a reputation among the women who attended as someone generous and approachable, one of the safer options in an environment where safety was not guaranteed. That reputation did not develop by accident. It was constructed through repeated behavior designed to produce exactly that perception. 2 women from the downtown Eastside survived encounters at the Pickton farm during this period and later provided testimony in court. Their accounts described the farm's conditions and Pickton's behavior in detail that would later align closely with the physical evidence forensic teams recovered from the property. In 2000, the city of Port Coquitlam shut Piggy's Palace down for zoning violations. The nonprofit status was revoked after the organization failed to file mandatory financial statements. The event stopped. The killing had already been underway for years. We are just getting to the part where the failures become impossible to ignore. If you are finding this case compelling, subscribe to Fatal Files. We go this deep on every case. Now, back to 1997. What follows is not a single missed opportunity. It is a sequence of them, spread across 4 years involving multiple agencies, multiple witnesses and multiple direct reports. Each one on its own might be explained away. Together, they form a record that is difficult to read without asking the same question repeatedly. At what point does a pattern of inaction become a decision? March 23, 1997. Pickton picked up a woman named Wendy Lynn Eisteter from downtown Vancouver and brought her back to the farm. Inside the trailer, he handcuffed her and attacked her. Eisteter fought back. The confrontation escalated and both of them were stabbed. She got out. She made it to the road and flagged down a passing car. Both Eisteter and Pickton were taken to Eagle Ridge Hospital for treatment. At the hospital, a staff member found a key in Pickton's pocket. It fit the handcuffs that were still locked around Eisteter's wrists. Pickton was arrested and charged with attempted murder, assault with a weapon and forcible confinement. He was released on bail of 2,000 Canadian dollars. Following the arrest, an RCMP officer entered a notation in the police database stating that Pickton posed a direct threat to women. That notation sat in the system. It was never acted upon. On January 27, 1998, all charges were stayed. The Crown assessed Eastside as too unreliable to serve as a witness, citing her history of drug use. The charges were eventually dropped entirely. Pickton's clothing and rubber boots, physical evidence from the attack, were bagged and placed in an RCMP storage locker. They were never submitted for forensic testing. In 2004, when investigators finally tested those boots, DNA from 2 murder victims was identified on them. The assessment from investigators was direct. If those boots had been tested in 1997, at least a dozen women might still be alive. September 1998. A farm employee named Bill Hiscox contacted the RCMP. He told them he had personally seen purses and identification cards belonging to missing women from the downtown Eastside inside the Pickton property. He named Pickton directly. RCMP officers took his statement and visited the farm. No search warrant was sought. No further action was taken. A separate tip reached police claiming that Pickton had a freezer on the property containing human remains. The information was set aside. No follow-up was conducted. March 2000. Lynn Ellingson was staying at the farm. She knew Pickton, considered him a friend of sorts, and had been spending time there. One night she woke up and noticed a light on inside the slaughterhouse. She walked across the yard and opened the door. She found a woman's body suspended from a meat hook inside. She ran. She did not call the police. She later testified that she had been afraid and financially dependent on Pickton for drugs and money. But there was an additional detail that emerged under cross-examination at trial. Ellingson admitted that she had used what she saw to blackmail Pickton, not once but on multiple occasions. She had direct leverage over him. She exercised it repeatedly for personal benefit. And she never reported what she had witnessed to any authority. Between 1999 and 2001, additional employees and associates who had spent time on the farm reported finding women's belongings on the property: purses, clothing, identification cards belonging to women who had been reported missing. Police conducted 3 separate searches of the Pickton farm across this period. Each search was concluded without flagging actionable evidence for prosecution. Running underneath all of this was a structural problem that compounded every other failure. The women were disappearing from Vancouver, which fell under Vancouver Police Department jurisdiction. They were being killed at a farm in Port Coquitlam, which fell under RCMP jurisdiction, 27 kilometers away. The 2 agencies operated on entirely separate information systems. Intelligence gathered by one was not automatically visible to the other. There was no coordinated real-time sharing. A man was operating in the gap between 2 law enforcement agencies that were not talking to each other, and the women paying the price for that were the ones both agencies had already demonstrated a limited institutional interest in protecting. Lorimer Shinher, working without resources or institutional backing, continued pushing for a warrant and surveillance authorization on Pickton's name throughout this entire period. She was denied each time. In 2001, the Vancouver Police Department and the RCMP finally established a joint task force called Project Even-Handed. Its mandate was to formally investigate the missing women cases from the downtown Eastside, dating as far back as 1978. It was a coordinated effort. It was the response that should have existed years earlier. And by the time it was formed, the window in which it might have intercepted Pickton before the scale of the crime became what it became had already closed. After years of tips, reports, warnings, and failed searches, the arrest of Robert Pickton did not come through the missing women investigation. It did not come through Project Even-Handed, or through any of the intelligence Lorimer Shinher had spent years accumulating. It came through a firearms tip. In early February 2002, a former employee named Scott Chubb contacted the RCMP and reported that he had personally seen illegal firearms inside Pickton's trailer on the farm property. That information met the legal threshold for a search warrant. It was the threshold that years of reports about missing women, personal belongings found on the property, and direct witness accounts had never been sufficient to cross. On February 5, 2002, officers from Project Even-Handed executed the warrant at 953 Dominion Avenue in Port Coquitlam. They were there for guns. They found several illegal and unregistered firearms. They also found something they were not looking for: jewelry, clothing, and identification cards connected to women who had been reported missing from Vancouver's downtown Eastside. One item was flagged immediately: an asthma inhaler with a prescription label bearing the name Serena Abotswe, who had been reported missing in August 2001. DNA testing of blood samples taken from a motor home on the property returned a confirmed match to Mona Wilson, another missing woman. Pickton was arrested that day on weapons charges and released on bail. But the investigation had shifted entirely. On February 22, 2002, He was rearrested and charged with 2 counts of first-degree murder. The farm at 953 Dominion Avenue was sealed and designated an active crime scene. It would remain one for the next 18 months. What followed was the largest forensic crime scene investigation in Canadian history. The scale of what investigators were facing had no direct precedent in Canada, so the RCMP sent 3 officers to New York City to study evidence recovery techniques that had been developed at Ground Zero following the September 11 attacks. At that point, the only comparable large-scale site investigation that had been conducted anywhere. Those methods were then adapted for the conditions at Port Coquitlam. The forensic team that assembled at the farm numbered 91 people. RCMP officers, forensic anthropologists, archaeologists, and archaeology students who were hired specifically to work alongside investigators processing soil as it moved along conveyor belts. The equipment brought in included 2 50-foot conveyor belts and industrial soil sifting machinery. Cadaver dogs worked the property in parallel. The scale of the physical search was considerable. Investigators sifted through 383,000 cubic yards of contaminated soil, excavating in places to a depth of 2 meters. What they recovered accumulated over months. 2 months into the search, a freezer was opened and the first remains were located. By May, 3 months in, half of Brenda Wolf's lower jaw was found in an animal trough. In June, the remains of Mona Wilson were recovered from 2 stacked plastic garbage pails on the property. In July, 14 hand and wrist bones were found in a pig pen, one of which was later identified as belonging to Georgina Papin. By the time the forensic search concluded, DNA evidence had confirmed the remains or genetic material of 33 women across the property. The total number of items catalogued during the investigation reached 235,000. The number of exhibits generated from the site came to 600,000. Among the items recovered from inside Pickton's trailer was a .22 caliber Smith & Wesson handgun found in the laundry room, with a sex toy attached to the barrel. DNA testing of the weapon returned matches to both Pickton and Mona Wilson. Also recovered throughout the property were night vision goggles, handcuffs, syringes, and personal belongings from multiple women who had been reported missing. The total cost of the forensic investigation through the end of 2003 was 70 million Canadian dollars. A further 46 million was budgeted to cover the trial phase. The province of British Columbia subsequently placed a mortgage on the Pickton farm property to recover a portion of his multi-million-dollar legal defense costs. In March 2004, the British Columbia government issued a public health warning that extended the reach of the case beyond the farm itself. Health officials stated that Pickton may have processed human remains into pork meat that was sold to the public. Neighbors who had purchased meat products from the farm were advised to dispose of anything they still had. This case gets more complex from here: the interrogation, the jailhouse confession, and a trial that raised serious questions about how justice works in Canada. Subscribe to Fatal Files so you never miss a case. Now, the interrogation. On the day of his arrest, Robert Pickton was taken in for questioning. What followed was an 11-hour interrogation that investigators and legal analysts have studied in detail since. Not because it produced a confession, it did not, but because of what Pickton's behavior throughout it revealed. He alternated between long silences and disjointed, wandering responses. When asked direct questions about the missing women, he deflected. He described himself as just a pig man. When the charges were put to him plainly, he called them a little far-fetched. At certain points during the interrogation, he laughed. Investigators showed him photographs of women who had been reported missing from the downtown Eastside one by one. He claimed not to recognize any of them. When he reached the photograph of Mona Wilson, he paused. At one point, the interviewing officer, apparently frustrated, said to him, "You're like the Pope for Chris sakes." Pickton's response was to say quietly, "I'm a bad dude." He repeated it several times. No further explanation. No context. The interrogation produced no statement that could be used directly as evidence. The recording was still played at trial. His detachment, his evasion, and that particular exchange were placed before the jury as evidence of his state of mind. The confession that mattered came later and from a different setting entirely. While Pickton was held at Surrey Pretrial Services Centre awaiting trial, the RCMP placed an undercover officer in his cell, someone Pickton had every reason to believe was a fellow inmate. Over several days of recorded conversation, Pickton talked. He described what he had done. He referenced numbers. And then he made the statement that was later played in open court in front of the jury in his own voice. "I was going to do one more, make it an even 50. That's why I was sloppy. I wanted one more." He had confessed to 49 murders. The only regret he expressed was not reaching his intended total. The legal process that followed Pickton's arrest moved slowly. A preliminary hearing ran from January to July 2003. The actual trial did not begin until January 30, 2006, nearly 4 years after he was taken into custody. The venue was the Supreme Court of British Columbia in New Westminster. The Crown assembled a 7-member prosecution team led by Mike Petrie. Darryl Prevet would deliver the opening statement to the jury. Pickton entered a plea of not guilty to all 27 counts of first-degree murder. Before the jury heard a single piece of evidence, the court spent most of 2006 working through the voir dire phase, the legal process of determining what evidence would be admissible at trial. Media were barred from reporting on the proceedings during this period. On March 2, 2006, Justice James Williams dismissed one charge entirely. It was the Jane Doe case, an unidentified woman whose remains had been recovered from the property but whose identity could never be established to the standard required for prosecution. On August 9, 2006, Justice Williams made the decision that would define the shape of the entire trial. He severed the 26 remaining charges into 2 groups. Group A consisted of the 6 counts supported by the strongest forensic evidence: Marnie Fry, Serena Abotsway, Georgina Papine, Andrea Josbury, Brenda Wolfe, and Mona Wilson. Group B contained the remaining 20 counts and was set aside pending the outcome of Group A. Williams determined that trying all 26 charges simultaneously would place an unreasonable burden on the jury and create an unacceptable risk of mistrial. The media ban was lifted on January 22, 2007, and the trial opened to public reporting. Darryl Prevet addressed the jury in measured, deliberate language. He told them that Pickton had murdered the 6 women in Group A, disposed of their remains, and that the evidence would demonstrate this without ambiguity. He also told the jury directly, "This will not be like a TV show." The scope of the forensic evidence the jury would hear about was significant. Approximately 80 unidentified DNA profiles had been recovered from the property, roughly split between male and female. The Crown expected to call at least 240 witnesses over a trial projected to last up to 2 years. Lynn Ellingson took the stand and testified to what she had witnessed at the farm in March 2000. Under cross-examination, she acknowledged that she had used that knowledge to blackmail Pickton on more than one occasion. Defense counsel challenged her credibility on that basis. Her core account of what she had seen was not successfully disputed. Scott Chubb testified about conversations he had with Pickton regarding methods for harming women who used drugs. His account was presented once, with clinical precision, and the prosecution moved on. Andrew Bellwood testified and corroborated the central details of Pickton's confessed approach to the killings. His testimony aligned with what the physical evidence had already established. Forensic anthropologists explained in technical detail the methods used to recover and identify human remains from soil that had been heavily contaminated over years. One aspect of the identification process stood out. In cases where victims had undergone root canal procedures, which removes dental pulp, the standard method of DNA extraction from teeth was not viable. Investigators developed a specific technique in response. The tooth was frozen in liquid nitrogen and then ground into powder, from which DNA could be extracted. That method was created for this investigation and had not been used in this context before. Former employees of the farm also testified, describing casual conversations they had witnessed or participated in with Pickton that touched on the farm's activities during the relevant period. 2 additional witnesses, Gina Houston and Pat Casanova, referenced in court record 2007 BCSC 1293, provided accounts relevant to the farm's operations and to Pickton's behavioral patterns during the years the killings took place. The defense did not dispute the existence of the forensic evidence. Their argument was narrower, that no direct evidence placed Pickton personally as the killer in each of the 6 Group A cases, and that given the number of people who had visited the farm over the years, other individuals could not be excluded from involvement. It was a challenge to the standard of proof for personal responsibility, not to the physical facts of what had been found. The jailhouse recording was played for the jury in full. They heard, in Pickton's own voice, the statement he had made to the undercover officer about his intentions and his regret at falling short of his target. The jury had the forensic evidence, the witness testimony, and his own recorded words. On December 9, 2007, the jury returned its verdict. On all 6 counts of first-degree murder, not guilty. On all 6 counts of second-degree murder, guilty. Under Canadian law, the distinction between the 2 carries specific legal meaning. First-degree murder requires the Crown to prove beyond a reasonable doubt that the killing was both intentional and planned in advance. Second-degree murder requires proof of intention but not of deliberation. The jury found that the Crown had established intention in each of the 6 cases but had not met the legal threshold for proven premeditation. That conclusion has been debated by legal scholars, investigators, and the families of victims ever since. The question at the center of that debate is straightforward: how a pattern of 49 confessed killings, carried out using the same property, the same methods, and the same approach to accessing victims, did not satisfy the legal standard for planning and deliberation has never been answered to the satisfaction of many who followed the case closely. 2 days later, on December 11, 2007, Justice James Williams presided over the sentencing hearing. 18 victim impact statements were read in court. Williams sentenced Pickton to life in prison with no possibility of parole for 25 years, the maximum sentence available under Canadian law for second-degree murder at that time. Before closing the hearing, Williams addressed Pickton directly. His words were measured and unambiguous. Mr. Pickton's conduct was murderous and repeatedly so. What happened to them was senseless and despicable. On January 7, 2008, the British Columbia Attorney General filed an appeal against the first-degree acquittals, citing concerns about evidentiary rulings made during the trial and aspects of the jury instructions. In 2010, the Supreme Court of Canada reviewed the case and upheld Pickton's convictions. The 6 second-degree guilty verdicts were confirmed and stood. On August 4, 2010, the Crown announced it would stay the remaining 20 murder charges against Pickton. The legal reasoning was straightforward. He was already serving the maximum sentence available under Canadian law. Additional convictions would not extend his time in prison by a single day. Proceeding with a second trial would cost millions, take years, and require surviving family members to sit through another prolonged and exhausting process with no change in outcome. For some families, that reasoning provided a degree of relief. For others, it meant that the women they had lost would never have their cases heard in a courtroom. Both responses were reasonable. Both existed simultaneously among the families affected. On July 30, 2010, Vancouver Police Deputy Chief Doug Leppard released a 450-page internal review of how the Vancouver Police Department had handled the missing women investigation. He presented it publicly and acknowledged, without qualification, that errors had been made at multiple levels of the investigation over multiple years. At one point during his statement, his voice broke. He said, "I wish from the bottom of my heart that we would have caught him sooner." That same year, the provincial government of British Columbia established the Missing Women Commission of Inquiry, chaired by retired BC Supreme Court Justice Wally Oppel. Its mandate was to examine the full history of the police response to the missing women cases and identify the structural failures that had allowed the situation to develop as it did. The final report was released on December 17, 2012. It was titled Forsaken and ran to 1,448 pages. The findings were direct. The police investigations into the missing and murdered women were described as blatant failures. The causes identified included institutional discrimination, a lack of leadership, a fragmented policing structure, and systemic bias against Indigenous women and sex workers. The report's central conclusion was that these women had been failed not once but twice, first by a society that rendered them invisible, and then by the police agencies that were obligated to protect them. The report issued 63 recommendations. The most far-reaching, the amalgamation of all lower mainland police jurisdictions into a single regional force, was never implemented. One structural outcome did follow: the formation of the Integrated Homicide Investigation Team, which established cross-agency collaboration on homicide cases across the Lower Mainland for the first time. In May 2013, 16 children of 9 victims filed a civil lawsuit against the Vancouver Police Department, the RCMP, and the Crown. The claim centered on the failure to warn vulnerable women that a predator was operating in the downtown Eastside and the failure to act on available evidence. Lawyer Jason Grattel represented the plaintiffs. In March 2014, a settlement was reached. 11 families each received $50,000 Canadian dollars. No admission of liability was made by any of the named parties. 2 of the 13 families involved declined to accept the settlement. Troy Bowen, whose mother Yvonne Bowen's DNA had been identified on the farm, spoke publicly about what the settlement meant to him. His question was simple and it did not have an answer. How can you put a price on someone who fed you, clothed you? The last part of this story is where it gets most significant, and most unfinished. Subscribe to Fatal Files. Every case we cover goes this deep. Now, the final chapter. In September 2016, the Canadian federal government launched the National Inquiry into Missing and Murdered Indigenous Women and Girls. Its mandate was broader than any single case. It examined systemic failures in policing, the justice system, and government policy across the entire country. The Pickton case sat at the center of that examination as one of its most documented examples of institutional failure. The inquiry's final report was released in June 2019. Its conclusion was unambiguous. The violence experienced by Indigenous women and girls in Canada amounted to genocide. That finding generated significant national debate. What was not debated was the underlying data. Indigenous women in Canada are between 5 and 7 times more likely to be killed by violence than non-Indigenous women. That disparity existed long before Robert Pickton. His case made it visible in a way that could no longer be managed with silence. While the national conversation was still developing, a separate fight was taking shape in British Columbia, quieter, legal, and still unresolved. The RCMP applied to destroy approximately 14,000 to 15,000 pieces of physical evidence collected during the investigation, citing the ongoing cost of storage. In November 2024, the BC Supreme Court ruled that it had jurisdiction to order the disposal of evidence, regardless of whether that evidence had been used at trial. Lawyer Jason Gradle, who had represented the children of victims in the 2013 civil lawsuit, confirmed he would seek possession of any evidence the RCMP no longer wished to retain, in order to support ongoing civil claims filed against both Robert Pickton's estate and David Pickton. At a press conference in 2023, Lorelei Williams, cousin of Tanya Holick, one of the 20 women whose charges were stayed, stood alongside family members of Sarah de Vries and publicly opposed the destruction of that evidence. Angela Marie McDougall, executive director of Battered Women's Support Services in Vancouver, argued that emerging forensic technologies made preservation essential, that evidence considered inconclusive in 2002 might yield identifications today that were not possible then. Sue Brown, advocacy director of Justice for Girls, framed the question plainly. Other jurisdictions keep cases open for 80 to 100 years. Why is the RCMP seeking to dispose of this evidence a mere 20 years after the farm was searched? As of 2025, civil litigation against the Pickton estate continues in BC Supreme Court under case reference 2025 BCSC 1921, De Vries v. Pickton. The case has not concluded. Robert Pickton did not die in a courtroom or in a hospital bed at the end of a long sentence. He died in prison violently on May 31, 2024. He was 74 years old. On May 19, 2024, at approximately 5:16 in the afternoon, during the distribution of medication at Port Coquitlam Institution in Quebec, a 51-year-old inmate named Martin Charest approached Pickton in the common room and attacked him. Correctional officers intervened and stopped the assault. Minutes later, Charest obtained a broomstick, broke the handle and drove the broken end into Pickton's face. Officers intervened a second time. Charest was handcuffed and taken to the Structured Intervention Unit. Pickton was taken first to Centre de Santé et de Services Sociaux de Sept-Îles and then airlifted to Hôpital Enfant Jesus in Quebec City, where he was admitted to intensive care. 12 days later he was pronounced dead from complications of the injury. A board of investigation was convened on July 5, 2024. It was chaired by Marie-Yves Chartrand with members Marc-Olivier Bouchard and Marc Filardo, and an independent observer, Reginald Laurent. The board's report was submitted on October 18, 2024. The independent observer's report followed on January 17, 2025. Both were released publicly on July 4, 2025. The findings identified specific institutional failures at Port Coquitlam. Cleaning supplies including brooms had been freely accessible to inmates in the unit, not stored in locked cabinets as security protocol required. The wrong family member had initially been contacted and notified of Pickton's death, an error that was only identified and corrected after the fact. The board issued 3 corrective recommendations. In July 2025, Martin Charest was charged with first-degree murder. In September 2025 he entered a guilty plea. His statement to the court was brief. He said, "I did it for the victims." That same year, the television series Dexter, Resurrection referenced Pickton by the name the pig farmer in connection with a fictional character who hosted parties with serial killers, a direct reflection of what Piggy's Palace had been. The reference prompted renewed public discussion about the case among audiences who had not followed it closely before. When news of Pickton's death reached the families of his victims, the responses varied in ways that reflected the different experiences each family had carried through the decades since their loved ones disappeared. Cynthia Cardinal, the sister of Georgina Papin, said that his death would allow her to heal and to move forward in a way she had not been able to before. Michelle Pinault, the mother of Stephanie Lane, a woman killed by Pickton for whom no charges were ever formally laid, said she was glad he was gone, and that justice had never been properly delivered for her daughter. Both of those responses were honest. Neither of them was wrong. And the fact that both could exist simultaneously, held by different women about the same event, is perhaps the most accurate summary of what this case left behind. A situation too large, too long, and too layered for any single outcome to resolve. Robert Pickton confessed to 49 murders. He was convicted of 6. 20 more cases were built, charged, and then stayed without ever reaching a jury. And there are DNA profiles recovered from that farm that have still never been matched to a name. The farm was 27 kilometers from downtown Vancouver. The warnings existed. The data existed. The name was in the system. The arrest came through a tip about firearms. The women were not failed because the information was unavailable. They were failed because of decisions, repeated, institutional decisions, about whose disappearances warranted a full response and whose did not. The Opal report used one word for it: forsaken. And it said it happened twice. Things that changed. The Integrated Homicide Investigation Team was formed. The National Inquiry was conducted. Investigation protocols were updated. Things that have not changed. The evidence destruction fight is still active in court. The civil lawsuits are still running. The farm at 953 Dominion Avenue is still sealed. The regional police amalgamation was never implemented. Every February, the Valentine's Day Memorial Walk takes place in Vancouver's downtown Eastside. Families and advocates have been making that walk since 1991. They have not stopped. The 6 women Robert Pickton was convicted of killing were Marnie Fry, Serena Abotsway, Georgina Faith Papine, Andrea Josbury, Brenda and Wolf, and Mona Wilson. 20 more never had their day in court. Some have no name at all. If this case matters to you, share it. Every person who watches is a person who knows what happened to these women. Fatal Files exists to cover cases that deserve more than a headline. Subscribe, leave a comment, and tell us which case you want us to cover next. We will see you in the next one.